right, so I think it's a good time to start. We have a good number now. Uh, Good morning, everyone. I hope you can all hear me. Um, I'm the convener and the lead facilitator for this training session. My name is Abayomi Okubote, and you get to see, my faces for the next 2 days. It is my pleasure to welcome you all to this important training. This is a rare opportunity for SMEs in Nigeria, Ghana, and Mozambique to acquire the necessary knowledge for resolving their disputes outside the courtroom and to also understand the principles of contracting. The training is essential due to what we call the prohibitive cost of resolving disputes through litigation. And this prohibitive cost has made litigation court actions to become unattractive and unaffordable for SMEs. By necessity, it is important that SMEs are able to resolve their dispute in a manner that is cost effective, efficient, and one that enhances business sustainability. As you see from this slide, SMEs are very important. In fact, the SME sector is the backbone of major economies, as well as they are important contributors to employment, economic and export growth. In Nigeria, as you see from the slide, SMEs contribute 48% of the national GDP and account for 96% of businesses and 84% of employment. In Ghana, SMEs contribute an estimated 70% of Ghana's GDP and account for about 85% of employment in the Ghanaian manufacturing sector. And if we move away to the southern part, South Africa SMEs account for 91% of businesses, which is quite high, and 60% of employment and contribute 52% of the total GDP. Now, despite the significant contribution of SMEs to different economies, challenges still persist, which hinder the growth and the development of the sector. There was an independent survey that was conducted by a UK agency on the small and on SMEs in the UK to discover the financial impact of legal issues on SMEs. The result of that survey is that SMEs SMEs are losing more than 13.6 billion yearly on legal issues. The survey has provided some shocking revelations that should make every business sit up and take notice because it is almost impossible to imagine what impact the loss of 13.6 billion will have on the SME economy. Another analysis by Escalate Survey 2019, which I've also put on the screen, shows that 96% of SMEs regularly experience commercial disputes. So as an SME business owner in any industry or sector, engaging properly with your legal issues and guarding against them, is going to potentially save you millions of naira every year. Simple matters like having contract terms and conditions checked or drafted properly to ensure your employment or contractual terms are clear will de-risk your business rapidly. And we have a session covering contracting, which we'll take shortly. It is also important to manage your disputes efficiently or establish safety nets to sidestep them. I've advised several SMEs, and some of their complaints are, as you see those complaints on the screen, legal action is difficult to justify because it takes longer to receive a payment overall, or they even say they paid in the end, legal actions pay in the end by their rules and not mine. It can be too time consuming and cost prohibitive. It is too expensive to instruct lawyers. Some even conclude that the process is not worth it and only puts financial pressure on the business. So whilst this complaint may be true for traditional litigation or courtroom actions as we know them, ADR provides useful alternatives that will not only help to obviate the concerns, but also help the business to continue to run as a going concern. So this training is designed to help SMEs understand the rudiment of contracting, nuances of contract management, dispute avoidance and prevention, the various ADR methods, the pros and cons of ADR, how SMEs can explore this knowledge for their business growth and sustainability. And to handle this, we have lined up some of the finest practitioners in the world of ADR to teach at this training. And we hope you find the sessions rewarding. In the event that you have any concerns or any questions, you can always reach me as a lead facilitator on the email addresses and also some of the associates working with us. Now, for the first session for today, starting with understanding the principles of contracting, we have Mrs. Laura Alakija, who is the managing partner at Primera Africa Legal, a top-tier commercial law firm in Lagos. Her expertise spans the disparate yet connected fields of disputes and transaction advisory services. She has over 15 years experience in project finance, power and infrastructure, asset acquisition, energy and natural resources, and dispute resolution. Laura is a fellow of the Chartered Institute of Arbitrators, an accredited mediator, and a certified ODR expert. She has served as counsel and arbitrator in several disputes and led the team representing clients in a number of big ticket transactions in Nigeria. Our profile is a long one, but maybe I will just cut it short at this point. It is my pleasure to welcome Mrs. Laura Alakija to take our session. Thank you.
Thank you, Abayomi. Good morning. And good morning to everyone on the platform. I thoroughly enjoyed that introduction and a bit of background on SMEs in Nigeria. I thought the statistics were quite interesting to see the sort of role the SMEs play in our economy and the level of employment they provide to the Nigerian. I didn't know, or I didn't have those figures, and I didn't realize that the workforce was larger among privately owned businesses, especially the small and medium scale businesses, as opposed to the large corporates. So that's really a good point for me to take off. The conversation is going to be brief, as relaxed and informal as possible, and I've deliberately avoided all forms of legalese so that we can have an open and an easy conversation. I would appreciate it if the session is as interactive as possible, so please feel free to drop your questions in the Q&A section while the conversation is going on, so that we can have a little bit of back and forth during the course of the presentation. Like Abayomi mentioned, I'll be speaking to you primarily about contracting, and the speaker who's coming in after me will give you a bit more information. Just a moment. Okay, got that. Can you see my screen?
Yes,
yeah? Okay, perfect. All right, so I will not go into much of an introduction because Abayomi has said everything, but I've provided a small outline into what the conversation is going to look like. And I will talk basically, about what to expect in terms of contracting, and then the different parts of a contract, what to do to avoid and prevent disputes as much as possible. So to save some of that revenue that Abayomi mentioned earlier, that SMEs lose to disputes and dispute resolution. And then I'll talk a little bit about negotiation and regulatory compliance issues. So just everything you need to know to put your business in good standing so that you don't have a lot of issues. So I'm digging right in. So I'm starting with contracts. And I think that the general understanding of what a contract is when people hear contracts, they think it's a legally binding document. So obviously it's in writing and people have to sign it before they have a binding agreement. To a large extent, that is true, but a contract sometimes could be oral. It could be written, so two parties may not sit down and sign it, and you can still find that it's a valid contract. And we'll talk about that in due course. But the key thing to notice about a contract is that it is usually between two or more people, and there's usually the intention to create binding legal obligations. A contract usually constitutes offer, acceptance, consideration. That means money should exchange hands. The intention to create a binding legal obligations. Capacity means that the parties going into contracts cannot be minors or mentally incapable of going into a contract. So they cannot be people of unsound minds. And the two parties should be aware that they're going into some kind of contractual relationship. So basically, those are the elements that form a contract. Now, I mentioned that sometimes a contract is oral, and I'll give you an example. If you, well, this is really before Uber, but let me work with this example. If you hailed a taxi, you know, and the taxi man stopped, and you said, "Oh, I'm going to," let me say, Ahmadu Bello Way. I think almost every state has an Ahmadu Bello Way. And you say, "I'm going to Ahmadu Bello Way," and the taxi says, "Okay, I'll take you there for 500 naira." And you say, "Okay," and you get into the taxi. You just entered into a binding legal contract with the taxi driver. The contract is for transportation of yourself and maybe some goods or whatever you're carrying from point A to point B. So you can see that there was an offer. The taxi driver made you an offer for 500 naira. There was acceptance. You accepted to pay 500 naira, I'm sorry. There's consideration that 500 naira is going to change hands between you. It's a legally binding contract. When you give him, or once you get into that taxi, he has a legal obligation to take you from point A to Ahmadu Bello Way. And you have a legal obligation to pay him 500 naira for taking you on that journey. Capacity may or may not apply here, because I think if you're under 18, you can still take a taxi. But under the circumstances of this conversation, or the context of this conversation, is that you must be of legal age to be able to enter into a contract, and you cannot be of unsound mind. So if you have someone with mental issues and the inability to understand what they are going into or what a contract is, cannot execute a contract. And of course, the two parties must be willing to be bound by the terms of the contract. So the taxi driver and yourself must be willing to, must know that you are getting into this relationship, and this is the purpose, and this is, you know, these are the terms, or this is the consideration that's passing. So in summary, that's what an oral contract looks like. The difference between that and a written contract is that you then sit down and you put all those into writing, and you put a number of other terms that govern the relationship. But I will not go so much into those details at this point in time. And I think that you will get this presentation deck after the meeting. So I will not go over everything that is written in each slide, but you will find that you can refer to this material. So in terms of running a small business, you will find that contracts are something that you deal with on a regular basis, whether they're written or oral, whether you deliberately put them into writing or not. Once you enter into an understanding with somebody that you supply XYZ service, obviously you've gone into a contract. So for instance, if your business is selling some kinds of goods or services online, you will find that once somebody goes to your page and places an order, you have a contract to deliver XYZ products to them. And you will see that all the 6 elements will run through your transaction. So there'll be offer, there'll be acceptance, there'll be consideration, there'll be the intention to create binding legal relations, there will be questions of capacity, and obviously the transaction will run both ways, so it will be mutual. So on a daily basis, you will find that you deal with contracts whether or not you're conscious of them. And it's important to bear that in mind, because what tends to happen then is, even for the unwritten contracts, you have certain legal obligations to your customers or clients to be met. This is why oftentimes disputes arise in business, because whether those obligations are spelled out in black and white or they are implied. Again, I'll go back to the example of the taxi driver. Even though your contract is not in writing, what is implied from that relationship is that the taxi driver, for instance, can drive, has the authority to drive that taxi, has a valid driving license, and he will take you from point A to point B without any interference or any unnecessary drama. So for instance, if you get into that taxi and the man says, oh, I'm really sorry, I need to take my mother to the market. I need to stop here and pick up my mother. And then after that, oh, I'm taking my son to school. I need to stop there and pick up my son before we get to Amadu Bello Way. Your first reaction will be like, excuse me, Oga, I'm paying for this ride. Please take me to my destination before you take all those details. So obviously, it is implied that when he has entered into this contract with you, if it is a car hire service, the expectation is that it is an exclusive contract. That means you will be the only passenger in that taxi until you get to your destination. So there's an implied term of exclusivity. Obviously, on your part, the taxi driver will have an expectation that you will pay your fare, you will not damage anything in his car, and you will not take any details. Excuse me. So there'll be some expectation that you will not say, oh, Oga, please wait, I need to polish my shoes, then I need to pick up my dry cleaning. It's a meeting I'm going for at Amadu Bello. You see, the taxi driver will also now raise his own objections. Madam, we've agreed 500 from point A to point B. You cannot add all this extra, because by adding those extras, it means you are changing the terms of your contract. So what was implied as, oh, these are the terms of this transaction, suddenly they are changing. And then you see that there's resistance, or there's an attempt to bill you a little bit more. So disputes generally arise from those kinds of circumstances where there are legal obligations and parties feel maybe those obligations are not being met, or there's some misunderstanding as to how they should be met. So this is why contracting is very important. It's important to know what service you're rendering, how and when you're delivering it, at what price, and to fix those in such a way that you manage the expectations of your customers or your clients, such that you don't run into issues in future. So very quickly, I'm going to run through the kinds of contracts that you're likely to encounter on a day-to-day basis. You have letters of intent, memoranda, I think that's the plural of memorandum, memoranda of understanding, confidentiality and non-disclosure agreements, sale and purchase agreements, service level agreements, or employment letters. I mean, these are just examples. Depending on your business, there's a wide variety of contracts that you could be going into. And you need those contracts to be able to spell out what service you're rendering, why and how, and at what price. So the next thing is, well, when putting together a contract, usually the drafting requires a step-by-step inclusion of the specific terms and conditions that cater to the needs of the parties under that contract. I'm not trying to teach you how to draft a contract, obviously, because under Nigerian law, as of today, it is still illegal for non-lawyers to draft contracts or other legal documents. And I think the exceptions are very narrow. Maybe to people that work for lawyers, you can draft contracts for your principal. So say you're a legal secretary, or you play another function in a law firm, you can draft a contract for your principal, but generally it's prohibited under Nigerian law, and I think it's punishable by a fine or imprisonment. So I'm careful not to tell you that please go and draft your own contract. But the idea is to point you in the direction of what to do and what to look out for. In my experience working with businesses and doing their contracting, I found that the clients I have who seem to have good relationships arising out of their contracts, or who have the best, let me not say good, because you can still have a good relationship with your business partner if you just call your lawyer and say, okay, take this, draft this and send it back to me. If you have a good lawyer, you should have no issue. But as a business person, this awareness is useful to you because it helps you to understand what product the lawyer is delivering to you and whether it satisfies your business needs. So that's one of the reasons for this conversation. In order to understand every contract document that comes before you, you need to bear in mind that your contract will be split into 3 key parts: the introductory part, also known as the recital, the commercial and operative parts. Usually they're just called operative parts, but I like to spell out commercial specifically so that for business people, those are the clauses that you are really interested in. It's good to be interested in all the clauses of your contract, but obviously you will lean more on your lawyer for all the other clauses. For the commercial parts of the contract, you'll give them the information, but they'll need to draft it in a way that covers everything that you desire. So it helps to have an idea what's going on in your contract, and the bulk of what really happens in your contract is in the commercial and operative parts. And then you have the concluding part of the contract where the parties sign and all of that. So the introductory parts, which is also known as the recitals, usually would contain the names of the parties, their addresses. If it's a company, it will indicate that, this is your registered address or your principal place of business. For some contracts, they might even want to add your registration number just to show that you are a valid legal entity. So it will have that, and then it will have the purpose of the contract. So if you look at a contract, you might see something like, whereas, then you will now see a description. Company XYZ is a seller of aluminium sheets. It's desirous of going into a relationship with company ABC for the distribution of their aluminium sheets in the eastern part of Nigeria. The parties have entered into this agreement to define the terms that govern their relationship. So some background information, then you now go into the operative part, and usually that operative part will start with language like, it is now hereby agreed as follows, or if it's a little bit more legalese, you see in witness whereof the parties now agree as follows. Then you will see your commercial terms. And so your commercial terms would usually then start with a description of the service. It will say the price. If the payment is, and it will say payment terms, so it could be a one-off upfront payment. It could be instrumental payments. It could be by wire transfer. It could be a check. It could be a cash payment. The commercial part spells out the details of the business. So you see that part, in my experience, is the part that most businesses pay attention to, because they want to see that you have everything that they require in terms of getting the commercials right. So that part will usually come immediately after the introductory part and the recitals. And then the operative parts, it now contains other clauses like it may spell out the obligations of the parties. So things like, for instance, it could say the seller would be responsible for packaging the products, transporting them this way, delivering them within XYZ days. So those kinds of terms. And then it could state the obligations of the buyer, or the buyer has obligation to make payments at so time. They have the obligation to pick it from port C, title and custody of the goods pass at this point. So it depends on what the parties agree. The seller may be responsible for the goods from the time they leave your shop till they arrive, meaning that if they get lost in transit, you have the duty to repay. Or the buyer may be responsible for the goods. That means custody and title would have passed to the buyer at the doorstep of your workshop. So once it leaves, if something happens in transit, then the buyer is responsible. Now, the nature of goods, the business the relationship, and what the logistics are for getting your services or your goods from point A to point B will determine what the risk and custody, what the custody and transfer of title terms would be. But those are examples of the kinds of things that you have in the operative parts of your contract. And I'll discuss those in detail. We also have what you call boilerplates. I'll discuss them further down in the conversation. And then eventually you have your concluding parts, which has to do with signatures. So all of these are broken down. I will not dwell too long on them, but I'll share enough information to at least give you an idea what you're looking for. So I'll start with the commencement. In the early parts of your commercial and operative parts, once you've passed the introduction, you will see something like the commencement. Sometimes the date actually comes before the recitals. It depends on how the contract is structured. So you will see that, oh, this agreement is made on the 5th day of April 2001. That's the date of the contract. Now, unless it states otherwise in the body of the document, there's every likelihood that that's the effective date. By effective date, I mean that once parties have signed it, that date on top is when the contractual relationship has kicked in. But sometimes you will have different dates in the same contract. So you will see that some of the examples I have there, you have the execution date, that's the date you sign, different from the effective date, that's when your obligations kick in. So you may sign the contract on the 1st of April, but decide somewhere in the body of the agreement that the contract becomes effective on the 15th of April. Maybe that's when you really need for your legal obligations to kick in. And when that agreement becomes effective on the 15th of April, you may decide that the commencement date for the services that you are going to render should start on the 30th of April. So this is, let me give you a practical example. This is what I mean. So in a contract like that, let's assume it is a contract for, let's say, supply of, let's say diesel, for instance. Let's say it's a contract for supply of diesel, and the effective date is first, the signature or the execution date is 1st of April. That means you've looked at all the terms, you get together, you sign it on the 1st of April. Nothing happens from the 1st of April because that's just the execution date. Note that these dates only apply in that way if they are indicated in the contract. Then your effective date may be 15th of April. So by 15th of April, your obligations can now kick in. And the buyer may now send you a request for 2,000 liters of diesel. When you receive it, you are now supposed to supply. But maybe you've decided that, commencement date should be on the 30th of April. So even if the seller, if the buyer sends you a request for diesel, for 2,000 liters of diesel, but you get that request on the 16th of April, for whatever reason, maybe 30th of April is the time that you would have had your diesel trucks and everything in place, so you can't start supplying till then. So people can pre-order, but you know that the commencement date for your deliveries is on the 30th of April. So that's what you've entered in your contract. So if somebody sends you an order for your 2,000 liters of diesel and you get the order on the 16th of April, you don't have a contractual obligation to deliver before 30th, because by your contract, you've agreed that commencement date for supply is on the 30th of April. So before 30th of April, all you can get is pre-orders. And then by 30th, your obligation to actually deliver the diesel to their physical location will now kick in. So, those are little nuances that, because it's your business and it's your industry, sometimes, and maybe you're still setting up, or you're running some things that will make it difficult for you to start delivery at a particular time, it's good to know those things and specify them to your lawyer so that they don't give you a document that gives you binding legal obligations before you are able to fulfill them. That's the point of understanding these dates. Okay, so someone asked a question in the Q&A session. I'm taking a break to answer it so that we'll have a small diversion before we go to the next part of the presentation. And this is from Deborah. Deborah says, if as a business owner you have a contract signed by both parties and there's a disagreement, will the contract be binding since it was drafted by a lawyer, but the owner of the business signed? Okay, I think they meant to say, but the contract was signed by both parties. So yes, it will be binding. Remember, what the law does not allow you to do as a non-lawyer is to draft contracts. But in terms of execution, you are the one that is entering into a business relationship and promising to do certain things. The only way the other party will be willing to agree that, okay, you can do this for them, is if you actually sign the agreement to confirm that, okay, I've agreed to do this. So it's actually legal. For written contracts, that's actually that's the way it works. That's for written contracts that require execution by both parties. Well, actually, I'll go into the nuances later, but that's the way it works. So you actually are supposed to sign it. You may not prepare the document, but from everything I've said, not only should you know the content, you should review it, and you should have a rigorous conversation with your lawyer before you sign it, but you are required to sign it. So please go ahead and sign once you have received the information. I see another batch of questions. I'll come back to those questions a little later in the presentation, because we'll discuss some of the issues that I can already see, and then I'll come back to that question. So I hope, Deborah, that I've answered your question. If I haven't, you can just indicate. So after you've agreed all your dates and everything, you put those in your contract and you move on from there. So that's an example of what your commencement should look like. Okay, so, in the commercial parts of your contract, like I indicated earlier, you will indicate details of the goods and services, price, payment terms, the nature and scope of relationship. I say that because the nature of some businesses may suggest. So, for example, the example I gave with the XYZ aluminum producing company that's looking for an agent to that's looking for, I shouldn't use that word, that's looking for someone to distribute their aluminum products in the eastern part of Nigeria. For that example, for instance, in that relationship, if the intention of the the aluminum manufacturer is that they just want someone who will buy in bulk from them at a discounted rate and resell. In that contract, you may see that the lawyer would indicate things like, oh, this contract is not intended to create a partnership, an agency, or an agency relationship. It's merely a contract for the supply of aluminum products from XYZ to XYZ. The reason that is said is often because sometimes you want to manage your legal liability. So, for example, you don't want a situation whereby someone who buys your steel products from the supplier now assumes that that supplier is your agent. That means they work for you, so you are responsible for their actions. So if they have any issues, instead of them dealing directly with that person, that distributor, they will now come and try to be suing you for the actions of that distributor. You want to state expressly in your contract, for instance, that this is a purely commercial relationship for supply of XYZ to this person who can then on-sell to the general public. So for that kind of, for that example of the nature and scope of the relationship, it helps to the parties to decide very early on in the transaction where responsibility and liability is. Once I've supplied my products to you and you've looked at them and you have certified them okay, you can't come back to me. Unless there's a fundamental defect, maybe like a factory defect. You can't come back to me if you mismanage them or they get stolen. If you promise somebody that you will deliver within 10 days and you have issues delivering, that's not my problem. So your customers cannot come back to me, they stop with you. We will agree what the terms of our relationship are. It's different from an agency. If I hire you as an agent, under the law, the principal and agent relationship is such that the principal will be liable for the actions of the agent. So it's different if it's an agency. And those are things that, you know, parties need to be careful and conscious about. If what you want to do is just supply, let the person on-sell, that's what you do. And you spell out in your agreement that this agreement is not supposed to create a partnership or an agency. So I am XYZ Aluminium Manufacturing Company. ABC Aluminium Seller and Distributor is not my employee, is not my agent, is not my partner. I simply supply in bulk to them. It may also be, for instance, that XYZ now wants to be the only person supplying your aluminium products in the East. Then you may now include the nature of your relationship will be in that scope and nature of your relationship, you may see things like exclusivity. So that person will be, that supply contract will be exclusive. That means you cannot enter into another supply contract with another person who is distributing aluminium in Eastern Nigeria. So that person, you may have seen it sometimes. You will see some companies will say, we are the sole distributors of LG in Nigeria, or we are the sole distributors of Samsung in Nigeria. It means they have an exclusive relationship. So everybody who wants Samsung products in Nigeria has to go through them. As a matter of fact, if you are in Nigeria and you want to buy 200 Samsung televisions, if you send your order to the Samsung head office in, is it Japan or Korea? Where is Samsung from? If you send your order to the Samsung head office, because of the exclusivity of their relationship with their sole distributor in Nigeria, please, that's an example. I don't know if Samsung has an exclusive distributor. But the point is, if you send your order to the head office in whatever country, there's every likelihood that they will refer you back to Nigeria and say, oh, go to this person, they will fill your order, because they have an exclusive relationship and it is spelled out in their contract. It will be a breach of the contract terms if they sell to you directly when they have a sole distributor in Nigeria. So those are the kinds of things that describe your relationship. And it is important to know these nuances, to understand them, and to look out for them so that you can guide your advisors. You can tell your advisors what you want. And I cannot emphasize this enough. Oftentimes, what I've seen happen in my time working as a transactions lawyer is that parties sit down, they negotiate, they agree what they want to go into. Then they now say, we need to sign something. Then they quickly call a lawyer. They give you a briefing. Oh, this is what we're going into. Please draft a contract. And then you go and you draft it and you come back, you give it to them. They just look over it. Okay, it looks okay. They sign and they go. They have not given you the benefit of the details and the nuances of their relationship. And if you didn't ask, or if your questions didn't go that far, you might miss out some things. So sometimes you will find that from a lawyer's perspective, lawyers prefer to at least be present during even your business negotiations. They may not say anything, or if the lawyer understands your industry and is a transactions lawyer, they may actually negotiate on your behalf and do strategy on your behalf. It depends on the scope of the engagement. But the point is, your advisors need to understand what you are getting into so that they can advise you properly. So advisors like your lawyers like your insurance brokers, like your commercial advisors. They need to understand what you are going to so that they can give you proper advice. All these are useful to avoid serious conflicts that will cost you good money in the future. Okay, so I'm taking a pause to answer a question from Gregory Okusi, and he says, what part of the contract will negotiations take place? And then if goods are missing in transit, who bears the loss? Okay, so I presume that by your first question, what you mean is at what point do you negotiate? It depends on the nature of the transaction and how the conversations go. Negotiations will happen once parties have established that, oh, I have something you want and you're willing to pay for it. Once you get a sense that that exists between the two of you, you may immediately go into negotiations. And negotiations start from the moment the person says, oh, can you supply me 20 crates of 20 crates of what now? 20 crates of electrical fittings. Can you supply me, or 20 cartons of electrical fittings? And you say yes. The next thing that's going to happen is negotiation. How much? Then you will now say, oh, this is my price. And the person will say, okay, maybe the price is good for me or it's not. They may make a counter offer. You may accept it. Then things like, okay, if I pay today, how soon can you deliver? You know, what are the payment terms? Can I pay? Pay in 3 installments? Can I pay? Sorry, I was lost for a moment. I will share my screen again and continue with the question I was answering. So I was saying, the second part of the question is if goods are lost. Hello?
Laura, can I quickly butt in? I was thinking that since you are still on slide 6, and you have 21 slides, possibly if you can take the questions after the presentation, so you can go to your slides, then answer all the questions later. Thank you.
Okay, that's fine. I'll conclude this answer and move on, even though I won't go over the 21, but it's fine. So I'll just conclude this answer and then I'll go back to the slides. Thanks, Abayo. Right, so the second part of the question was if goods are missing in transit, who bears the loss? Again, it depends on the terms of the contract. It depends on what structures you put in place for custody of the goods while in transit. And I'll give you an example. It may well be that your contract for the supply of 20 crates of 20 cartons of electrical fittings, that you agree to deliver. If you agree to deliver, it means that it's more likely than not that what you agree in your contract is that title and custody will not pass until the electrical appliances have arrived at the buyer's location. Sometimes, depending on the nature of the relationship, there may be a third party in between. So you may have a transporter that you use. And sometimes parties enter their agreements in such a way that title and risk pass to the transporter. So the transporter will be responsible if anything happens. And then the owner now takes title and risk when the buyer, takes title and risk when the goods arrive at their destination. That's a possibility. So it's possible that title and risk will pass from the gate of the supplier, or to the buyer. So if that's the case, then the buyer will be responsible from the moment, once the moment the crates leave the seller's gate, it is now your responsibility. If anything happens, that's not the seller's problem. Those could be because that's what you've agreed. It may be that you've agreed to come and pick up the goods. So once they've handed it over to you, there's no reason why they should bear responsibility. So whatever the circumstances are, parties will agree where title and risk pass. Sometimes title and risk may stop at the gate of the seller, but it will pass to a third party. That's your transporter. So depending on the agreement between parties, the title and risk may pass to the transporter. So if anything happens, it's the transporter that will be held responsible. Then when they get to you, you now take custody. So the other answer to that question is that sometimes it is possible that title and risk only pass when they are delivered to you, meaning that it is now the seller who will be responsible if something happens, or if it has passed to a transporter, then it's the transporter that will be responsible if something happens. But it's good to get these things clear at the outset so that one does not run into issues. So I'll go back to my presentation, and then like Abayomi recommended, we'll come back to the question and answer later. So in answer to that question, you see that we've mentioned a little bit about risk. So the next part of your operative parts of the contract will look at things like risk and how you allocate them. The one thing I'm going to start by saying about risk is, in order to effectively mitigate risk, parties need to allocate risk to the person that is best able or best suited to bear it. I'll repeat myself. When you are looking at the risks in a transaction, risk allocation needs to be done or needs to be assigned. As you allocate for each risk, you allocate it to the person best suited to bear it. Now, best suited does not mean that the bigger or the richer party is the one that bears the risk. But if they have the capacity to, and they are willing to for whatever reason, that's fine. So in terms of risk allocation, what parties do is, sometimes in your contract, you will see things like representations and warranties. So representations will be like the things you say, like, I am the owner of this product, I have the authority to sell it, the product is of XYZ specification, it will provide X, it will perform XYZ functions, and things like that. So representations, you say things that establish your authority and your ability to enter into the transaction. Warranties would essentially spell out what happens in certain circumstances. So the popular warranties that everyone will be familiar with are the ones you see on goods. If you buy a product, you will see that it has a 1-year warranty, it has a 2-year warranty or 5-year warranty. That warranty simply means that for this period while you are using my product, I'm assuring you that it will perform XYZ service. In the event that it doesn't, then I will do XYZ. And warranties are very important. You need to only provide warranties as to the things that you can actually do. And you need to be careful that your warranty does not cost you far more than the value of whatever product you're selling. So it's good to look at your warranties, which is why sometimes you see for some products, warranties are given for certain parts of the product, not the entire product. Some people have return policies for a duration. For huge projects, you have what you call a commissioning period. You can call me back anytime. If one part of what I've built or constructed for you is not working, you can call me back. And so all of that is provided in your warranties. Now, if anything goes wrong, what do you do? That's where risk usually comes in. Who pays for what if anything goes wrong? And it's important to find ways to manage those risks. And sometimes it may even be that none of the parties to the contract can bear the risk. That's where insurance comes in. Some risks are such that you can't bear it, I can't bear it, we insure it. So if anything goes wrong, it is the insurance company that takes this risk. You pay a premium for it, and they cover that risk so that if anything goes on, they are the ones that pay. So in your contract, you will see things like indemnities. After you've given your warranties, and you said if anything goes wrong, I can do, or these are the things I can do for you within this period, you will now have to indemnify the person you've given that warranty to. So what an indemnity means is that if, for instance, the thing that we are saying should not go wrong, if it actually goes wrong, I will bear financial responsibility for it. So if you even spend money, let's say I sell you a car and I give you a warranty that this car, will perform X, Y, Z, you can come back, and then you are traveling from Lagos to Port Harcourt by road. And as you are going, out of nowhere, the brakes suddenly fail and you run into a tree. Thankfully, nobody is hurt, but the car is damaged significantly. And you spend another 1.2 million naira to fix it. An indemnity means that because I've taken responsibility for this, and this brake failure, which falls under all the warranties I've given you, this brake failure, I will now indemnify you. So if the accident had happened in a location where you could tow the car back to me, I would fix it. But if you had to fix it, then I will refund you. So I will indemnify you and hold you harmless against liabilities, damages, losses, and expenses incurred as a consequence of, okay, this one is third-party claims. I'm reading my example. So it depends on what the indemnity is. Those indemnities help to give your clients comfort that you can do what you say you can do, and you are ready to put your money where your mouth is. Now, the challenge with indemnities is that sometimes if you don't couch or cap your indemnities properly, they can wipe you out. I'll give you an example. A couple of years back, there was a pipeline. There was a pipeline leak was it in the Pacific Ocean now? I'm talking about the BP case. So British Petroleum was exploring crude in the sea, in the ocean, and there was a pipeline break, and the crude seeped into the water and affected surrounding communities, and they were working through a subcontractor. And the damage and the claims and the fallout of that oil spill was so huge. British Petroleum paid in billions of dollars, literally, to clean up the spill, to compensate people that had been affected by the oil spill. And all of that. Now they were working through a subcontract, the contracting between those two parties. Imagine if the subcontractor had just generally said, I will indemnify British Petroleum for any oil spill in the ocean. That subcontractor, because they don't have the capacity to pay for that kind of damage, their business will be wiped out because their indemnity was so wide and it was not capped, and the risk was placed with a party that could not bear it. That is just an example, but BP had to pay everything, and that contractor was still in business because I've not seen the terms of their contract, but I imagine that it played out that way because they had allocated risks in a particular way. Maybe BP had some insurance they had to fall back to in order to cover that. But that's an example for you to understand. So those clauses, they fall in the parts of the contracts that parties generally don't pay attention to. They're called boilerplates or midnight clauses. You just leave it for your lawyers. But sometimes it helps for your lawyers to understand the intricacies of your business so that even when it comes to these kinds of clauses, they can adequately protect you. I've talked about pretty much everything in here. Okay, how can liability be limited? I've mentioned. So what you can do to limit your liability is sometimes you cap your liability. If you indemnify somebody, you can say the limit of my liability in respect of anything that goes wrong in this transaction is XYZ amount. usually it's a reasonable amount, 100,000. If the other party, but if it does go wrong, I will cover you, or I will cover all your losses to the tune of, and then you cap your liability. That's one way to limit your liability. You can always use insurance, like I mentioned. Can I hold someone jointly or severally liable? Those are legal terms. I don't really want to go, and both of you are, say, for instance, supplying a third party. What you want to look out for is that you are only liable for the things that, so that's what is called several liability. Several liability means that I'm responsible for my part, company B is responsible for their part. If the parties are severally liable, it means it's only my part of the contract that I'm liable for. But if you are jointly liable, it means if anything goes wrong on either side of the transaction, if you've agreed that you'll be jointly liable, then the third party or the counterparty can come against any one of you or both of you for something that goes wrong, even if it's not your side of the transaction. So those are little things that you should pay attention to. Are any types of damages excluded? In Nigeria, punitive damages, you can't just claim damages because you want to punish somebody. In a contract, what we have are what are known as liquidated damages. I don't want to speak too much legal, but it's a reasonable pre-estimate of what you anticipate you will lose if something goes wrong. This is useful for, especially for the seller side of the transaction. If I give you a contract to supply me 2,000 liters of diesel, I gave you the contract on the 16th of April, and you were supposed to, our contract was supposed to commence on the 30th. So you have made all arrangements to supply by 30th. Then at 11:45 p.m. of the 29th, I now quickly send you a message to say, oh, sorry, I don't need that diesel anymore. I hereby cancel my contract. If there's nothing in the contract that says, first of all, you can't cancel within XYZ hours of delivery, that's a problem. Or if you do cancel, then this is the implication. So liquidated damages will just look at the scenario and say, if you cancel the night before delivery, I've already bought this diesel. You will be liable to still pay XYZ for terminating this arrangement without a reason at such a minute after I've expended XYZ. So liquidated damages will look at the value of what you would have expended in preparation for that delivery, and then you put your liquidated damages at that value. It has to be reasonable. It has to show this is what you will lose before you can put it in a contract. When you do so, then it's easier when you go to ADR or you go to the courts to recover that amount of money. So that's just an example of the safeguards you can put in your contract. Okay, we'll talk about force majeure when we go to the Q&A, so I'm going to skip that. The essential part is to know that you can negotiate all aspects of your contract. Termination, these all fall under, so in your operative part, apart from the commercial aspects, there's what you call boilerplates. I call them boilerplates, or they're called boilerplates because those are like the legal clauses. So all those indemnities, warranties, and all those things, a lot of it is legalese, and commercial transactions, people tend to leave that for the lawyers to draft. And it's all well and good. That really is the lawyer's job. But it's good for you as a commercial person to know what to expect so you can give your lawyer some guidance what you want to see. Basic thing about termination is some kind of notice. What's a reasonable period to give notice? If the person wants to terminate because of a breach, is there a cure period? So if we have a contract for supply of diesel, let's use our diesel. If I miss the first delivery date, do you automatically terminate, or can you give me notice to say you've missed so delivery? I'm giving you 10 days to meet up with that delivery, otherwise I will terminate. That's a cure period. So it means you have 10 days to cure that default before my right to terminate kicks in. Those are the little nuances you can look at when you're looking at your contract, and then you can decide that certain terms or clauses survive termination. Depending on the nature of the relationship, things like confidentiality usually survive termination. It's not stated, even if you don't state it expressly, things like the dispute resolution clause may survive termination if the subject matter of that contract, something goes wrong even after the end of the contract. So maybe your last supply was on the 10th of December, and the contract is supposed to end on that 10th of December. But you supply that diesel and there's something wrong with the quality of the diesel, and it now affects all of my equipment and it causes damage to my equipment. The dispute that arises out of that, even though our contract is over, that dispute will still run because it's arising out of that contract. So some things will survive termination. It's just good to know those things. Then subsequently in this training, you will hear a lot about governing law and the dispute resolution clause. The key thing you need to know about the governing law is that whatever your contract is, you need to decide what law is applicable. Usually, if the parties are in the same country, obviously, very likely that's the law you will use. When you have parties across jurisdictions, sometimes they may choose the law of a third country that is neutral, or they may choose the law of either country, maybe depending on where the subject of the transaction is. So where the business is located might be your choice, or you might choose which of the countries has a more developed legal system that can help you with your disputes. The beauty of ADR is that, you know, it does away with some of these things so that whatever your location, if you once you've picked your governing law, even if you are doing your ADR in another location, you'll be able to, you know, manage how that law affects your disputes and how your dispute is interpreted without having to go to the country where that you've picked as governing law. But if you pick jurisdiction, if you pick a particular country, let's say it's a court dispute and you pick a particular jurisdiction, it means that when there's a court case, that's where you're going to go and resolve your disputes. If you don't physically go there, now that a lot of virtual things are happening, you may have to hire representation from that country. But you will hear a little bit more about governing law when the ADR aspects of this training come up. Then there's the dispute resolution clause. This is where you decide how you want to resolve your dispute. If you don't want to go to court for starters, you will very quickly say that you want to go to arbitration or mediation, or you might even, you know, do it in tiers. We want to negotiate and try to settle among ourselves. If after 15 days it doesn't work, we'll go to mediation. Once the mediation is done, our time of settlement will be binding on the parties, or you go and register it in the courts. I won't go into so much detail about what happens with how the ADR clause is applied, because Mr. Ojo, who is going to do the ADR training after this presentation, will go into those details with you, so that I don't preempt him and say what he's planning to say. I've dropped the sample dispute resolution clause, but I'm sure he'll probably have a better sample for you. But those are some of the clauses that you come in contact with when looking at your contract, and you need to bear a lot of what I've said in mind in negotiating and agreeing the terms of those contracts, so that you can avoid subsequent dispute as much as possible. And when parties have done that back and forth and they've had that negotiation, it also helps so that the post-contract relationship is seamless. Whoever your business partner is, from how you negotiate your contract, they will see whether you are fair, whether you're rendering your services honestly, whether you are concerned that the product is suited to them, whether you will take care of them if they run into any issues. That helps. Properly negotiated and documented contracts help for good post-contract relationships. And if you add the icing on the cake by choosing ADR, it also helps, because a lot of the ADR mechanisms, they focus on building the relationship, preserving the business relationship, as opposed to, just deciding right and wrong and bringing everything to an end. Sometimes that's inevitable, but you will find that these actually help to, ensure that your business relationships last longer. So finally, for your execution, remember we mentioned capacity earlier. Only people who are above the age of 18 can sign contracts, and people who are of sound mind. So once you come to the signature, if it's a legal entity, you will see things like in witness whereof the parties here to have caused their respective common seals to be affixed. Sorry, the language is a bit what's the word I'm looking for? Is it colloquial or dated? You understand? But there's simple language. There's more simple language for that. The point is, if it's a corporate entity and you have your own separate personality, then you will see things like the parties have caused their common sales to be affixed. If you're entering in your own capacity, you will see things like they within named Mr. XYZ, you know, now hereby executes this document. Then you sign and you provide your date. So it's important at the end of the document to ensure that if it's in your personal capacity, then it indicates that it's just you that is signing. If it's a corporate entity, then you indicate, you know, that the corporate entity has endorsed. That's what the common seal is for, to show that it is an action of the corporate entity and that the person signing it is signing on behalf of that entity. It's good to always know that whoever is signing on behalf of an entity you are going into a contract with has the authority to sign it. So sometimes when you are negotiating your contract, you will see that some of the requirements we need a board resolution. It's very important because sometimes people can indicate that they have the authority to bind a company and they may not. There are certain instances under the law where even if they don't have the authority, because the authority is apparent to an outsider who doesn't know the inner workings of the company may still be bound. But there will be instances where the company is not bound and you would have signed all of these contracts for nothing and you lose a lot of money. So it's very critical to look at things carefully. So before you sign a contract, seek legal advice, read the document, including the fine print, ensure that it reflects the terms and conditions that you wanted. Allow yourself time to consider. Sometimes it's a negotiation trick to tell you that, oh, you must sign it within the next 3 hours because the counterparty doesn't want you to read it. Be careful. Don't be pressured into signing anything if you are not sure. When you are signing a contract, don't leave blank pages or blank spaces so that the page cannot be swapped. Usually the recommendation is that you should initial on every page. So after you've signed at the end of the document, just come and initial every page so that one page cannot be replaced because you've initialed on every page. So it's only the contract that has your initials on every page that's the valid contract. And of course, you should get a copy of the contract for a record so that I've had instances where people come to me, oh, I have this dispute with this person. We went into a contract for this and I say, where's your copy? Oh, they just gave me in their office and I signed. I'm like, but I need to see the contract to understand what you signed and what you got into. And it's a hassle because once you've entered dispute, it's hard for you to sort of go back and find a way to collect that document. So those are the key things that I think are important to observe when you're at the early stages of your transaction so as to prevent disputes. So be conscious of those things. The other thing I want to add, for instance, because of technological disruptions, you will find that sometimes the contracts you are going into, they are not your traditional contracts where you have to sign. You go to a website, you want to do something, and you see terms and conditions, and you have options, agree or do not agree. Once you have to agree to proceed. That does not mean you shouldn't read it, because sometimes when you read it, you will find terms that you cannot live with. Then you may look for an alternative service provider whose terms are different. Because once you click agree, it means that you have agreed to the terms and conditions they put on that site. In the event of a dispute, that drop down menu that says agree or do not agree, that's what's going to govern the relationship. So it's very important, especially for a business relationship, to ensure that you don't fall into some of those pitfalls. I won't dwell long on this one, but the point of this graduating staircase is just to show you that dispute prevention will cost you the least. So it is cheaper to put together your contract, negotiate it, and close a good contract than to have a bad contract that will give you issues. It's also easy to do your direct negotiations. You may agree in your contract that, oh, the CEO of each company will get together and negotiate in event of a dispute. Unless they can't reach a middle ground, then you escalate. Then you may now get a neutral, whether it's mediation or arbitration, or there's what we call early neutral evaluation. to review your dispute. Or you may have a standing dispute resolution advisor. That comes with some cost because it means you are paying this person consistently. But, well, it depends on the arrangement. But I won't go again into too much details on that because Mr. Ojo will come to that. And then you have your arbitration and your litigation. So it's really up to you how you want your dispute resolved. Usually from industry to industry, it differs, and people sort of get a sense of what they need to do. So I'll move on from this point, and I'm gradually coming to the end of the presentation. I don't have a lot more to say after this, but one of the other things that you need to pay attention to apart from your contracting is your compliance. Regulatory compliance is important. Now, I'm aware that in Nigeria, that's a bit of a challenge because there's a lot of, should I say, there are so many regulations to comply with. The system is not properly unified, but it's important. And I've highlighted some of the key regulatory agencies. There will be more, or there will be different agencies depending on your business sector, the nature of your business, and what you need to do. But if you want to have some kind of legal personality, you may want to register with the Corporate Affairs Commission, even if it's a business name, which is not separate from you. But at least it's a name that you can trade in. You can still register that with the CAC. But those come with minimum requirements. You need to file annual returns. That means you need to keep your books. You need to be able to say on a year-on-year basis, this is the value of my business. You need to file those returns with the CAC so that they know you are in business and this is what you are doing. You need to register with the tax authorities. It's very important. And I say it's very important because even though our tax system is not very efficient in chasing down people who have not paid their taxes to pay their taxes, as a small or medium enterprise, what you want to do is be compliant in the event that you need to bid for certain kinds of jobs, or you need to apply for certain sorts of grants or funding. There's so many reasons why your books need to be in order, why you need to keep good records, why you need to file your returns as and when due. And I don't think these things cost a lot. The Federal Inland Revenue Service will assess your tax based on profits. So if you keep your books properly, you've got a good tax advisor, and you separate your income, your profits from your revenue, you'll be able to tell what portion of your income should be taxed. And it's only good record keeping. One of the mistakes that most small businesses do is that they don't draw the line. So if they don't draw that line, it becomes difficult. It becomes difficult to rightly assess if you are making a profit or not. So there will be little expenses that you may not account for. Once you've accounted for the value of the goods, you've accounted for the logistics, you don't account for other things. If you run a generator at your premises, you don't account for that. If you spend your airtime to do business calls, you don't separate it and account for it. Those are all your expenses. And you need to be able to separate your business expenses from your personal expenses so that you can back them out of your business expenditure and leave what is really truly just your profits. That's what the government can tax. If your books are properly done, you will find that you will save yourself a lot of money in taxes. So it's very important. Depending on your business, you will need licenses and registrations, trademarks, NAFDAC, SON, copyrights. It depends on the sector. It depends on the structure of your business. And it depends on the activity you're carrying out on the marketplace. For every kind of business, it's easy to find out those licenses, permits, authorizations that you need if you speak to the right consultant. So I will recommend, as much as possible, find affordable consultation that will meet your business needs. I won't go into details of all this. What I would add, I had added some bonus slides, and I won't go into all of them, but I'm just going to flash one to show you that technology has disrupted the way law is practiced now. So legal service delivery is largely commoditized. It means that you can find it online. Because it's commoditized, it's already pre-prepared for you. It's affordable and it's easy for SMEs to work with. There's a bunch of other legal service providers that I've listed somewhere in my presentation. These are just to give you direction where to look in case you are looking for legal representation that will help you cover some of these things, but will not bore holes in your pocket. That's one way to go. Find a legal service online that will give you pre-drafted contracts, but can review them to customize them for your needs. Meaning that if you find a pre-drafted agreement, but there are some things that don't work, there's the option for you to call and speak to a lawyer and adjust them. You will find that some of these services will cost a fraction of what it will cost if you walked into a traditional law firm and said, I need a lawyer to draft this for me. I'm not trying to demarket any lawyer. I'm one of them, and I work in a traditional law firm, but if you're looking for something affordable, it helps to go with the pre-packaged products because they've been pre-packaged and they're sold to a wider audience. The lawyers delivering those services are able to give it to you at a very reduced price. So that helps you to manage your financial outlay for documentation purposes and for compliance purposes. I think, having said all that, I can skip to the last slide and say thank you for listening.
Thank you, Laura.
Thank you.
So I think we should still be able to take 2 questions.
Okay.
So there's one that I saw on how do you enforce an oral contract when there's no evidence that you entered into it? And the person has provided an example that when you rent an office space and the agent says you can use certain facilities and comes back to say to rescind or go back from such agreement, that how do you enforce the contract when it's not written? Do you want to provide a quick response to that?
Yes, I would like to provide a quick response to that. I would start by saying very carefully that typically contracts that have to do with, or transactions that have to do with property, typically should have written contracts. So you would want to, in the first instance, as much as possible, avoid an oral contract for the lease of a property. No matter how basic it is, my first recommendation, this is for dispute avoidance purposes, is to avoid an oral contract that has to do with property, so that you don't run into these issues, because you'll be living in the property and there's a variety of services you may require. There's a variety of activities that the lessor will not want you to do in their property. If it's not written, it will be difficult for either party to establish that, oh, this is what we agreed. So unless you have some form of evidence to show that this is what your oral contract contains, it will be difficult to prove it. The oral contracts that are easy to enforce are the ones that, they are ones of general usage that the implied terms are pretty clear and obvious. Those are easy to enforce. But for something like a lease agreement that is not normally oral, it's usually in writing, it will be difficult to enforce an oral. So please, as much as possible, put your contract in writing. And sometimes it helps. And I'm not saying this is not ideal, but where you don't even have a signed contract, if you have written records of your communication or correspondence on those things, it might help your case. So if you have email exchanges, WhatsApp exchanges, text messages that you've exchanged to say, oh, I'll do this for you, it helps. That may be one way that you can establish your case.
Thank you very much. Just on the final note, do you want to quickly speak to the question of force majeure and whether COVID-19 will constitute a force majeure event?
Right. This is an excellent question, and it's the question of the year. In all of this COVID period, we have seen a lot of issues around force majeure. Personally, I've seen a lot of back and forth movement between parties when it comes to force majeure. Force majeure is generally something that the parties could not reasonably envisage, which serves to suspend their obligations in a contractual relationship. And because they could not reasonably anticipate it, for a duration, you can suspend those activities until some kind of normalcy is returned. Then your business can carry on. Now, COVID-19 would probably be force majeure if it fell into the scope of how your force majeure clause was drafted. The challenge with the COVID-19 is that most people didn't anticipate it. So when they drafted their force majeure clause, they gave a list of the kinds of incidents that constitute force majeure. And COVID-19 was now not one of them. So it now became a question of, oh, is this force majeure? Is this not? And it's a bit nuanced. So depending on how your contract was drafted, that would help you to determine whether you can really say that force majeure, that COVID-19 constitutes force majeure. But COVID-19 is a global phenomenon. So in spite of the contract, you'll find in some instances that people are able to still suspend the performance of contracts despite the way their force majeure clauses were drafted. And then for those that didn't have force majeure, fortunately for them, then the doctrine of frustration could apply to say, you know what, the pandemic has frustrated my ability to perform this contract at all. So, you know, in this instance, it can actually bring the contract to an end. But again, it depends on the circumstance of each case. So the short answer to that question is, it depends on your contract and the circumstances of your case.
Okay. Like my friend will rightly say, a smart way for a lawyer to end every conversation is it depends. Thank you very much,
Yes.
Laura, for that very informative and educating session.